The, the Union Judiciary or the Supreme Court. The Supreme Court is necessary because in a federal political system, the function of Supreme Court is to interpret the Constitution and to protect the fundamental rights and to do situation based analysis of the Constitution. Composition. The total sanction strength of the Supreme Court is 33 judges, including the Chief Justice, and the appointment of judges is by the President of India after consultation with the other judges and the President. The appointment is done by collegium system of judges, and the qualification for appointment 5 years as a judge of any high court in India and 10 years as a high court advocate, and he should also be a distinguished jurist in the opinion of the president. Oath of affirmation. He will bear true faith and allegiance to the Constitution of India, and that he will hold the sovereignty and integrity of India, and that he will perform the duties without fear or favor, without affection or ill will. Terms of office. Once appointed, he retires at the age of 65 years, and the judges may be removed on the ground of proved misbehavior or incapacity. Independence and impartiality. The judiciary is independent of the executive and legislature because it is necessary for the judiciary to do impartial justice between citizens and also between citizens and the government, besides state government and central government. The appointment of judges. Neither political bias nor personal favoritism plays an important role. There is a security of tenure, and only proved misbehavior or incapacity can remove the judges on the address of each house of the parliament. Salaries are charged on the consolidated fund of India. No discussion is done on the conduct of any judge. Only genuine criticism of judges is allowed. The jurisdiction of the Supreme Court says that the powers the court exercises to carry out judgment and to interpret laws and to settle disputes. The original jurisdiction is when the Supreme Court has the first authority to decide after hearing the disputes between the Government of India and the other state governments, and the disputes between two or more states, enforcement of the fundamental rights. Appellate jurisdiction. In constitutional cases, the Supreme Court has to interpret the Constitution and to have a last word on it. And in civil cases, if the High Court certifies that a case involves substantial question of law and the case needs to be decided by the Supreme Court, then an appeal can be done. Appeals in criminal matters. With a certificate from the High Court and without a certificate from the High Court can be heard in the Supreme Court of India. The Constitution gives a special power to the Supreme Court, which is called special leave, except for armed forces. The President may take the opinion of the Supreme Court on matters of public importance, and the Supreme Court is not bound to express any opinion on matters related to public opinion. A convicted MLA or MP can lose seats right away. Protector of fundamental rights. The Supreme Court is a protector of fundamental rights, and the fundamental rights are habeas corpus, mandamus, prohibition, quo warranto, and certiorari. The Supreme Court is a court of record, and its judgments are not to be questioned anywhere. The Supreme Court has the power to punish for its contempt. Public interest litigation. Any public spirited person can move to the court on the behalf of general public. Writ of habeas corpus. Writ of habeas corpus means that you may have the body or to appear before the court in person without any representative. Mandamus. Mandamus means that we command. And prohibition. Prohibition means that the Supreme Court can prevent the inferior court from exercise of powers to which it is not entitled. Certiorari. The lower court is asked to hand over the court of record or the record of a case to High Court or Supreme Court. The writ petition is a preventive one and certiorari is a remedial one. This needs to be taken care. The judicial review powers are there in cases between the union government and the state, and to review all national and state laws, and to be a guardian of fundamental rights. Right to life does not include the right to die. This is an example of interpretation of laws by Supreme Court, where the case of suicide was to be punished as decided by Supreme Court. The wages of casual workers were to be same as regular workers, and compulsory narcotics or polygraph tests were illegal. Honor killing were illegal. Limitations on the power of judicial review. The ninth schedule added after the first constitutional amendment made the laws in ninth schedule free of judicial review. Significance of judicial review is that it is a written constitution, and constitution has provided limited powers to the center and the states. Only Supreme Court has the power to settle the disputes between the central government and the state governments. The legislature does not possess the impartiality needed to explain what the law means. So, this was the Union Judiciary or the Supreme Court discussed. If you have any questions, you can ask in the comment section, or you can ask when we are live on YouTube.